The Supreme Court lashed out at the lower courts and the high courts for the reluctance in granting bails, despite the top court repeatedly pushing for the need to be liberal, especially when custody is not needed. The Apex Court recently heard a bail plea of an accused who was in jail for 14 months, even after the charge sheet, only because framing of charges process was delayed. The court remarked that 40% of such cases should be dealt with at the lower court or the high court levels. The court had recently said that denying bail where custody is not needed amounts to intellectual dishonesty. My colleague Harish is joining me live right now to get us more details. Well, Harish, it's not the first time around that the Supreme Court has emphasized for the need for a bail, especially in cases where custody is not essentially needed. But the lower court and the high court seem to be having their way when it comes to not granting the bail, and the reluctance is what's being called out by the Supreme Court. Can we now see that this perhaps can work as a precedent, that the lower court and high court may have a more liberal approach when they're deciding on the custody of many of these people who end up languishing in the jail without any fault of theirs?
Yes, that's right. This is precisely what Justice Sanjay Kishan Kaul, who was heading the bench, said that this is the fifth or sixth time that we are reiterating this rule, these guidelines in the past 1 year. But sadly, this is falling on deaf ears, and expressed anguish at the manner in which the trial courts, that is subordinate courts and high courts across the country, are flouting the Supreme Court guidelines, which clearly says that unless and until custody is must, if the custody is not required, if the investigation is over, and the maximum punishment in a particular crime is less than 7 years, in the interest of right to life, right to freedom, right to personal liberty, and the accused must be set free and should not be sent on remand, or bail should not be denied. This is the dictum which the Supreme Court had issued, but Supreme Court repeatedly find that the subordinate court judges and high courts are not complying with these guidelines, and as a result, Supreme Court said the impact of it was that an extra 40% cases are coming to the Supreme Court in the form of appeals, which means that if the lower court and high court complies with the guidelines, the pendency in the Supreme Court can be cut down by 40%. The Supreme Court said, sadly, the Supreme Court judges are busy hearing bail matters, while this can be disposed of by following Supreme Court guidelines and also upholding the interest of the accused, and also reiterated that jail should be an exception and bail should be the norm. This the Supreme Court has been reiterating for at least 10 times in the past 2 years. This is what Justice Sanjay Kishan Kaul said. And also remember, coming to a question, the Supreme Court has been of late taking very serious note of this violation by the subordinate courts and high courts, and recently, remember, directed the Allahabad High Court to send one of the district judges who have been rampantly flouting these guidelines, and directed that he be sent back to the Judicial Academy for a refresher course. So this is the serious view Supreme Court is taking off late. Supreme Court has begun the crackdown regarding the violation of its guidelines. And this particular case, this was a shocking case wherein an accused was forced to languish in jail for 14 months extra just because the charges were not framed against him, and the charge sheet had been filed, in fact, more than one year back.
Clearly, as far as it's also a human rights violation, where people have to languish in jail just because there's a delay in framing of charges as cited by the Supreme Court. And perhaps this is where the subordinate courts are going to take a lesson from it and perhaps not carry out intensive custody charges against these people. But thank you, Harish, for getting us all those details. We also have a panel of guests joining us this afternoon to discuss this further. I am joined by Mr. KV Dhananjay, who is a Supreme Court activist. I beg your pardon, Supreme Court lawyer. I'm also joined by Mr. Ansh Singh Luthra, who is a Delhi High Court advocate. And I'm also joined by Rajeev Bhardwaj, who is a public servant and a citizens' rights activist. Good afternoon to all of you, sir. Thank you so much for taking our time and joining us over here at Mirror Now. My first question would go across to Mr. KV Dhananjay, who is a Supreme Court advocate. Mr. Dhananjay, how do you look at the fact that Supreme Court has to, for the around fourth to fifth time, emphasize on the fact that jail can only be an exception and essentially bail is the norm, mostly in cases where custody is not really required? Why does the top court have to time and again remind the subordinate courts about that bail is the norm? Why is there a reluctance by the lower courts to try and implement that?
Well, the courts below have read a lot of judgments coming from the Supreme Court on why the courts below would be the first safeguard against encroachment of a personal liberty by the state. But the problem arises from two other things, which is that, actions speak louder than words. So, everybody should applaud what the Supreme Court has just done, but we also should take note of certain other things, which is how closely does the Supreme Court follow this very own principle in its actual practice. Every day or every week, you get to hear about some activist who's been languishing behind bars for a very long time, whose bail application comes up before the Honorable Supreme Court, and the Supreme Court does not deal with it expeditiously. And this gets reported. And this is what the trial courts tend to take greater note of. They tend to take less note of what is put on paper, but would take greater note of how the Supreme Court itself puts this laudable principle into practice. Just yesterday, we got to know that the Supreme Court did not decide upon the bail
petition.
But Mr.
Dhananjay, the Supreme Court is citing an example where a particular individual had to be in the custody for 14 months just because the process of framing the charges was delayed even after the charge sheet. And the Supreme Court is also trying to underline the fact that if the lower courts are going to be tending to the bail pleas, then perhaps 40% of the pendency of cases can be mitigated at the Supreme Court's end. And that is the reason why there's also this whole time-consuming process of pendency of cases, because of which several important other cases are not taken up by Supreme Court. Do you think there is a need for the lower courts, subordinate courts, to be able to adhere to it?
Nobody can fight what the Supreme Court has said on principle. What the Supreme Court has just said is, of course, laudable, is, of course, great. But the real issue lies in the fact that the trial courts are not going to be fully impressed or guided by what the Supreme Court says orally or what it puts on paper. The trial courts are also going to look at what the Supreme Court itself actually does. The Supreme Court, there are so many benches in the Supreme Court. There are, I think, 13 to 14 benches, different benches of the Supreme Court. They're not consistent themselves in upholding this very principle. Now, the principle that we're talking about today has come from a particular bench. Do all the other benches subscribe to that principle? I doubt. And that is where the trial courts get confused. And the trial courts tend to just, take it more casually. And for what the Supreme Court said yesterday to become the firm law of the land, it's important for all the benches of the Supreme Court to affirm it and then to live by that principle. Now, unfortunately, half the benches probably in the Supreme Court don't, subscribe to this very principle, and that is where you find the trial courts, becoming more casual.
A point taken where you're saying the Supreme Court will also have to walk the talk in many cases. I have paucity of time and I have to go to the other guests as well. I'm also going to go across to Mr. Luthra, who's joining me right now. He's an advocate from the Delhi High Court. Mr. Luthra, how do you look at this warning bell that the Supreme Court has sounded, not for the first time around, but they have cautioned the lower courts to say that what is the reluctance or the reservation in granting bail, especially in cases where custody is not paramount, was not exactly important. Do you think that the lower courts need to introspect and perhaps inculcate this a lot more in their judgments?
When we talk about this particular case, there are two reasons why this rebuke has come from the Honorable Supreme Court. One, of course, your colleague also highlighted that there is a 14-month delay in framing of charges after filing the charge sheet. The second is, which is in the previous order of the Supreme Court, that all the other accused have been granted bail except the applicant over here. So this is something that the trial court and the High Court must and should have taken into perspective while rejecting the bail. However, I mean, there are various considerations for bail, and there is a need for balancing the requirement of custody and the requirement of personal liberty of the accused under Article 21 of the Constitution of India. And various factors are considered by the High Court or the Supreme Court and even the trial court while granting bail. I'll take your viewers through some of these, and that will help understand the issue on a larger scale. One is, for example, the type and severity of offense. In case of a small cheating offense, there'll be a higher likelihood of getting bail, but an economic offense which is of where public money of thousands and thousands of crores involved, like the present case where 5,400 crores are involved of public money. In economic offenses, getting bail will be slightly higher. This is also reiterated by the Supreme Court in a case called Y.S. Jagan Mohan Reddy versus CBI, where they say that economic offenses are a class apart and are deep-rooted conspiracies which affect the economy of the country. So that is type of offense. Second is the stage at which bail is applied.
But Mr. Luthra, over here we are focusing primarily on the rights of the citizens over here. Many of those who have to bear the brunt of the delay in the process of either framing of charges or the fact that the matter is being transferred from one court to the other and they're not being granted bail. And that is exactly where I want to bring in Mr. Rajeev Bhardwaj, who is the public servant and citizens' rights activist. Mr. Bhardwaj, we've seen both the lawyers arguing it out for the Supreme Court and for the Delhi High Court. But what happens to citizens at large? That is exactly the interest that the Supreme Court today has prioritized, that there are several cases in which there are people who are left to wait, not because the charge sheet is not formed, not because they've not complied with the due norms, but it's only because the delay is in the process of framing the charges. And that is the reason why perhaps the lower courts have to be a little more reasonable and humane in their approach towards granting bails.
Yes, Samia, as a citizen, I can only relate with the news and the views which are coming from the other public dignitaries. I take it from the stage when our Honorable President expressed the same views and observations before the Chief Justice of India in a function, where she flagged the issue of the most common person at the district level or at the taluk level. And they used to share the same views or same frustration with the Honorable President when she was a public representative. Now, similarly, just 15 days back, a similar kind of observation has come from a state chief minister about the functioning of the judiciary, where the public is losing faith. And now I take this observation of the Supreme Court in the same spirit, where it is flagging that the lower judiciary is not functioning in the manner it should. That means they are questioning the effectiveness of the lower judiciary. You can imagine more than 99% of the population is dependent upon the lower judiciary. As far as the bail is concerned, bail is a matter to be given or not to be given. It falls under the judicial prudence. So our friend has expressed their views. I will not go into the merit of that, whether it should be given or it should not be given. The thing is that it should be heard effectively, efficiently on a real-time basis when the petition is moved. There are many high courts in India, especially I know one in Bihar, where your bail application may not get listed even for months. We are happy sitting in Delhi, where we can get any bail application listed within the Delhi High Court or Supreme Court within few days. But there are many high courts where the bail application will not get listed even for months. Similarly, the lower court,
right.
It is what the Supreme Court is expressing is a kind of paralysis of decision making by the lower judiciary, and what the expression they have given, it will get limited to the judgment which they have given. We are thinking, or we have a wishful thinking that this observation will make a radical change down the line. I'm doubtful. But this is a problem. Having
Well,
flagged the
it may
problem.
take time. It may take time, Mr. Bhardwaj, but the record had to be set straight, which the Supreme Court has already done. But like our guest, Mr. Dhananjay, was also pointing out, but somewhere even the Supreme Court will have to walk the talk in many of their cases. And like Mr. Luthra was mentioning, there are certain compulsions whereby which immediate bail may not be granted, as there are several considerations for the bails that need to be factored in. But thank you so much. I will have to wrap this conversation over here. Thank you so much to all of you taking our time and joining us over here at Mirror Now as we discuss this.